All right, good morning. Thank you to John and the NHA Services team for organizing this webinar. Um, we are going to be covering background screening, best practices, and compliance, and specifically how that works for Nebraska hospitals. As a newer NHA Services preferred business partner, quick background on OneSource. We are located in Omaha and have been assisting organizations with screening for nearly 20 years. While we do serve clients across the U.S., most are located right here in the region, and we have been fortunate to assist many Nebraska hospitals and looking forward to meeting many more as we continue this partnership with NHA Services. All right, so a little bit about myself. My name is Neil Jostin, and I will be leading us today. I am currently the Vice President of Business Development here at OneSource and have been with the organization and in the background screening industry for over 11 years. In that time, quite a bit has changed. In my early years, a lot of emphasis was on explaining to organizations why they should be doing background screening. Now, nearly all organizations, whether it's a hospital or small accounting firm, have a screening process in place. Uh, so now I kind of shift my focus to helping organizations ensure they are compliant, creating the best candidate experience, and then receiving the best information to make informed hiring decisions. So I do spend a lot of my time working with hospitals and our clients to determine how we can best streamline or bridge the gaps in their screening process. So today I'm going to cover several areas. Background screening compliance, having a good policy in place, the disclosure and authorization forms, and adverse action. We'll also take a look at how to determine if you are receiving quality data in your current screening process and what you should be including in your background check. Then we'll dive into healthcare exclusions. What are they? Why are they searched? And then look at the different options available. And of course, at the end, we'll have some time for questions and answers. All right, so background screening compliance, not the most fun topic, so I'll keep this moving for everyone's sanity. But before we get started, it is important to note who governs background screening companies, which are also called consumer reporting agencies or CRAs. You'll hear me refer to organizations like OneSource as a CRA or a background screening firm throughout the presentation today. The Fair Credit Reporting Act, also referred to as the FCRA, regulates the collection, dissemination, and use of consumer information. This does include consumer credit information, which is a background check. Now, just because it says credit doesn't mean it's a credit report. The FCRA governs consumer reports. Those are background checks. So the Federal Trade Commission, or the FTC, and then the Consumer Financial Protection Bureau, the CFPB, are the two government agencies that are designated to enforce all of the regulations outlined within the FCRA. So the FCRA in this case is intended to protect consumers from misinformation that may be used against them. So using a consumer report to screen applicants or employees requires following the FCRA specific guidelines. On top of the FCRA, the Professional Background Screening Association, or the PBSA, you'll see their logo there on this slide, offers an accreditation program for consumer reporting agencies, which would include OneSource or whatever screening company you may be using already. This accreditation program started about 9 years ago, and in order to stay accredited, you are audited every other year for EEOC and FCRA compliance. Any screening firm that has this accreditation, you can rest assured has met these requirements and is following and is compliant with the industry. So in the end, ultimately, it is your responsibility as the employer to follow the requirements you are regulated by. Then it's the background screening company's obligation to keep the reports that we're providing in regulation. And then it's both of our jobs to follow that Fair Credit Reporting Act, or the FCRA. Along with the regulations, there are additional healthcare industry requirements that come into play for Nebraska hospitals. This includes the federal requirements, which we'll get into a little bit later with healthcare exclusions, and then state-specific requirements, thinking like the Nebraska Department of Health and Human Services. So, on top of having to pay attention to the FCRA as an employer, you also need to keep an eye on the EEOC. In 2012, they released a doozy. It is a 64-page guidance on the use of criminal records for employment. And I'm assuming that none of you have read this unless you have had trouble sleeping at night and it was something your doctor prescribed to you to read. But there's certainly some good tidbits in it. And overall, it really is just a lot of legal chatter. So the main points that they outline in the guidance are that you should have a solid background check policy in place. In fact, they outlined several cases that led to the guidance. And the first thing that the EEOC asked for when they were arriving at these employers was to see a copy of their background screening policy. First of all, if you don't have one in place or you're frantically searching your HR files to check if you have one, don't fret. OneSource has sample policies and outlines that we can provide to you, including a great one from SHRM, which is the Society of Human Resource Managers. In a nutshell, there are 3 areas the EEOC looks for that you should have in your policy, and we'll take a look at those here. Targeted screen. You should build your policy with the applicant's position in mind. As Nebraska hospitals, you likely have clinical or healthcare employees, and then those that may fall into more of a non-clinical business, office, admin type role. You should be using the background check results to make decisions specifically on the criminal conduct tied to that position in question. So a few examples. Let's say someone is applying for a janitorial position and they have a DUI in their past. They aren't going to be operating any heavy equipment. They're not driving a hospital vehicle. Should that DUI disqualify them from employment? Maybe not. On the other side, let's say someone has a felony theft charge. They might not be a great candidate for an accounts receivable position or in the pharmacy department. So, and then, sexually based offenses, what's the gravity of that offense? And what's the position that they are, what position are they in that could be putting staff or patients at risk, right? The second part that the EEOC mentions is time limits. They are essentially saying that no crime should bar someone from a position indefinitely. So people ask, what time frame is acceptable? I always say that the federal government is a good start. If they're doing it, it's going to be hard for them to bring a case against anybody doing the same. So they currently have a policy on contractors that they released after the Navy boatyard shooting in 2013, where that individual did have a previous record, but was still working there. And it's 5 years for misdemeanors and 10 years for felonies. So some companies do 5 years misdemeanors, 7-year felonies. Some do 7 and 7. Regardless, get it in writing and get it in your policy. So I get this question a lot. What happens if an applicant's been in jail the last 15 years and got out last week? Well, that's certainly outside that 10 or 7-year time frame, right? Well, I'm sure a few of you ask about charges or convictions once a job has been offered. If you do, there's language that you should utilize. And that is, do you have charges or convictions where the court's jurisdiction is pending, continuing, or ended less than 7 years ago? So to read that again, do you have charges or convictions where the court's jurisdiction is pending, continuing, or ended less than 7 years ago? So it's very important that this says continuing, pending, or ended. It doesn't mean that it's the actual court date, right? Many CRAs or background screening firms will tab the court date as their close or the date that the conviction happened as their 7-year clock. So the individual has been in jail for 15 years, they get out a month ago, and you ask them, have you been convicted of a crime in the last 7 years? Well, their answer is going to be no. They've been sitting in jail. So by saying pending, continuing, or ended, that clock actually starts when they get out of jail, which is 7 years from that date. So 7 years after they are released from prison, after they finish their parole, after they finish their paying off their fine. And that's actually what the EEOC lays out, is that's when you can be and should be looking. In the FCRA, when they have jurisdictional requirements, it's always from the end of that full charge cycle and that final disposition. So hopefully that makes sense. The final component is quality data. Certainly my favorite part of it. You should always be making decisions on real-time original source records. What exactly does that mean? That means that if I leave my office today and decide to go have some drinks at the bar and drive home, resulting in a DUI, my charge would be in Douglas County, where I am, Douglas County, Nebraska. The only way to get that charge, if you were to do a background check on me, up to date in real time, would be to search directly at the Douglas County Courthouse. So many companies provide database or instant reports, and those only rely on purchased or scraped data. The problem is that there are over 3,300 counties in the US, and not many of them sell their data or allow companies to extract that information for their own databases. So if you're receiving database only searches in your background check, that should be a big red flag. And we'll dive into that a little bit more here in a minute. But let's take a step back and remember that the FCRA. So how do they step into the background screening world? The most important thing is that disclosure and authorization. You have to obtain this consent prior to running a background check. It seems like common knowledge. You'd be surprised how often I do receive a phone call from someone that wants to do a one-off search and a random hire because they don't feel that they don't look trustworthy. This is always the first thing I bring up. You're going to have to get consent to conduct this background check. Oh, well, then we don't want to do it. Click, they hang up. So hopefully this is something that you are all doing already. The disclosure must lay out what you are searching. Is it criminal records, motor vehicle records? Are you doing employment verifications, credit reports, social media searches? You do need to include all types of information that may be gathered. If it's not in the disclosure, you can't search it. So then the applicant has to authorize that it's okay for you to do it. And that's the signature portion of this disclosure and authorization, where you can collect their PII as well, which is their personally identifiable information, social security number, date of birth, things we need for the background check. The FCRA states that you must allow, that you must offer everyone that gets to this step in the hiring process a copy of their rights. That is going to be the summary of rights under the FCRA. It explains their rights and what they can do to dispute any charges. They are entitled to a copy of their report, and there's a bunch of government contact information in it. I always compare this, to use a healthcare example, to HIPAA form. Obviously, they're different things, different governing bodies, but you need to at least offer it to them. They don't need to take it with them, but it must be offered. All that said, people are always trying to streamline their process. OneSource has a great disclosure and authorization on our website. It is great language that encompasses nearly everything that you could or would want to search, and it was put together by industry attorneys. So please feel free to reach out to me, and I'd be happy to provide you a copy of it. It is in a Word document, so you can edit it to fit your facility. But nearly every time I give a presentation, I get contacted by somebody afterwards saying, is my disclosure and authorization acceptable? Don't be shy, ask. We can help and ensure you have the correct information. But like I said, everyone's trying to streamline their process now. So this is a great opportunity to put a plug in for OneSource. With the disclosure and authorization form being so important, we do have the ability to have the applicant sign this authorization electronically. It is eSign Act compliant, and it makes the process entirely paperless. The applicant enters their own information, and that's that PII, social security number, date of birth, address, their name, and then they sign that consent electronically. It is a very simple process and is great, especially if you don't have somebody nearby or coming in when you're doing the interview process, or maybe they're working in a remote position. So on top of that disclosure and authorization, we also have ban the box. Hopefully everybody's familiar. I'm sure you've heard of this at some point. I always use the example of FedEx when it comes to ban the box. They used to post job ads in the paper and it would say no felonies accepted. That is what the world is trying to get away from. Ban the box is sweeping across the nation. It's not just state specific, it's also city and industry specific. So there are all kinds of organizations that have these laws in place now. In Nebraska right now, any government position falls under ban the box. So in a nutshell, it's good practice not to say anything about criminal records up front, or ask about criminal records in the job posting, or blanket say that we don't accept anyone with a criminal record. All right, so this is how the FCRA affects the applicant and the employer, but there are also reporting rules for background check companies. So we always get the statement that you can only report negative information for 7 years. Well, this is true in a lot of cases, but the FCRA does have the following exceptions. Bankruptcies can be reported for 10 years, and criminal convictions, and I'm not talking diversions, drop charges, etc., but convictions can be reported indefinitely. There are a lot of state-specific rules that add to that, so there's a different layer. Here in Nebraska, we do not have any of those jurisdictional rules at this point, so we can provide information back as far as the courts have record of. In Nebraska, this is typically back into the mid to late 90s in most counties, so you could be seeing records that are 25 plus years old in some cases. I know we're all Nebraska hospitals, but if for any reason you have an office or location in another state, you do need to follow the state-specific rules for those individuals. Here I have listed the 5 strictest states: California, New York, Minnesota, Oklahoma, Colorado. California, for example, has a restriction that only 7 years of records can be reported. So if you have an office in California for some reason, or you're hiring someone that will be working remotely there, you must follow that California Consumer Protection Act. I talked about the PBSA, the Public Background Screening Association accreditation earlier, but most accredited companies like OneSource do have staff and safeguards in place so that we take this compliance into consideration on every order. If we see a current address in California, or it's one of our California clients, we know when to cut off that reporting. I should mention Colorado. I know we had a few people from the Panhandle on the webinar today. Their restriction is 7 years from final disposition on anyone that's making less than $75,000 a year. That law was enacted after the FCRA amendments in 1996. So technically the FCRA may trump that Colorado restriction. I recommend consulting with your attorney just to be sure. But Colorado does also have ban the box in several large cities, including Denver. So if you're going to be hiring anyone in Colorado, again, I suggest just connecting with your attorney or labor lawyer just to ensure that you are following the right regulations. All right, so last part of compliance. I told you to try to get through this as quick as possible. Adverse action. Hopefully everyone is familiar with this as well, so I'll be brief. When you decide not to move forward with an applicant after the results of the background check, you must inform them. This is done through a pre-adverse action notice letter. The first step, notify the applicant. This is that pre-adverse letter, and it lets them know that there were some adverse findings that were found in the background check. You must also provide them a copy of the report and then that summary of rights, that same one that you offered to them up front with that disclosure and authorization. The applicant then has the option to dispute the findings of that report. So let's say it's the case we hear a couple times a year where it's my evil twin, we have the same birthday, our social security numbers are nearly the same. Every applicant has a chance to review the report and question what came back. At OneSource, we have an easy portal on our website for applicants to do that. to dispute the charges. And when that happens, the client is notified immediately, and then you actually need to hold that position for them until that report is rerun, which we do at no cost, and that the issue or that dispute is resolved. If the applicant does not dispute the report, which I assure you happens 99 out of 100 times, you just have to wait a reasonable amount of time, which the FCRA states kind of loosely, but we suggest 5 business days. Then you send the adverse action letter. That's step 2, which officially lets them know that you're moving forward without them. So your screening provider should provide these letters to you. At OneSource, we do provide these letters on every completed report. With the click of a button, you can print it off or email it to them. But we also offer a completely automated process that handles all of it with the click of your mouse. Click start the process, and we'll send that letter to the applicant electronically. Once they open it, we track that. And then our system will start that 5 days, and it'll automatically send the adverse letter as well. And then if they don't open it for any reason, our system's set up for us to print it off, email it directly to them, and mail it as well. So it makes the process entirely seamless for you, and it's super easy and streamlined for you, our client. All right, so got all that boring stuff out of the way. Thanks for bearing with me this far. Now let's take a quick dive into the quality of data in criminal searches. What you should be searching as a Nebraska hospital. We talked about quality of the data earlier with that EEOC guidance, that states that you should always be making your decisions in real time with original source information. So as a quick recap, that means searching directly at the county level in most cases. There are other places that original source data can be obtained, like district or federal courts, but third-party databases are not compliant for hiring purposes without verifying the results at that original source. So again, if your reports are coming back instantly, or your screening provider is searching a database and only verifying at the county level, you should be searching at the county level first. So what is included in a complete comprehensive criminal background check? Our recommendation is to always include, at a minimum, these 6 components, and I will jump into each one of them here briefly. Applicant history trace. This is our language, what we call our search here. But what it really is making sure you have the correct data and information on the applicant up front. You'll see other screening firms call this a social security trace or an applicant verification. Regardless, typically it includes these 4 components. We do an SSN trace, which provides us the ability to search additional names or addresses that they had. Death Master Index, we will make sure that social security number is not listed on a deceased for a deceased person. We'll do a full name, address, and birthday verification. Do what we can to make sure we have the correct information up front, and then it is completed by a human. Make sure this isn't a database only solution, that it's automated, that it is conducted or at least reviewed by a human. With this, it does set us up so that we can see, again, those additional names or addresses that the applicant had or are tied to that social security number. We then use that information and search at the county level where they had lived. So in my mind, this is the most important search, county criminal. You're going to see over 90% of all records in the background check come back at this level. It is real time. It is original source, which again is that EEOC requirement. And most background check screening firms will provide this search statewide whenever it is available. When I started here at OneSource 11 years ago, there were roughly 19 states that did have a statewide justice system where all counties report to equally. Now there's 24, and that does include Nebraska. So OneSource has a integration to the justice system where we can see all counties in the state. If they lived in Douglas County, and that's the only address they've had for the last 7 years, we're still going to be able to see if they went down to Lincoln for a football game and had a charge in Lancaster County, or we're out in Kearney and had a charge in Buffalo County. So I can't emphasize this enough. Nebraska is statewide. It is a big red flag if your screening firm, your current vendor, is only providing you individual counties in Nebraska. Great example is that I live in Sarpy County, just south of Harrison Street, which divides Douglas and Sarpy County here in Omaha. Never lived in Douglas County. So my address in Sarpy, if I were to run 400 yards across Harrison Street and rob the quick trip, I would be charged in Douglas County. If that record or that crime was committed in Douglas County, that's where I'd be charged. So if you were only searching where I lived, you'd search Sarpy County, but less than half a mile away, I committed a charge and had a record in a different county. So we do include all 93 counties across the state, and it's imperative that you make sure that is what you are receiving from your vendor as well. The record should also be provided back as far as legally reportable. In any jurisdiction, again, in Nebraska, late 90s, early 2000s in most counties. So, and then here in this infographic, again, I want to highlight that make sure you're doing the searches back as far as you can from that final disposition too. So someone was in jail for 10 years and your vendor is only providing you 7 years of records. Well, guess what? That's not going to show up because they were in jail 7 years ago and weren't committing crimes. So make sure that you're doing it from that date they got out of jail. That's when that 7-year clock should be starting. All right, so now I warned against using databases before, well, actually several times, but the EEOC doesn't like it. The fact remains that there's loads of information out there. So why not include it, just not as your primary search? The database that we utilize contains over 650 million records. So when it is used properly, it can cast a wide safety net to help find potential records in other locations that they hadn't lived or had been on vacation and had a record, for example. Somebody never lived in Minneapolis. They went up there for a weekend a couple years ago, were arrested, had a charge, never lived there. Again, that would be a way we could potentially find that record. At OneSource, we then verify any records found in that database at that county level, always statewide when available, to ensure that it is up to date and in real time, and it's not a dismissed record, it was expunged, or incorrect information. All right, so that brings us to federal criminal. This is the most commonly omitted search from background check companies, yet the records that are found at the federal level are of the highest level and some of the most heinous crimes. Anyone tried and convicted at the federal level in federal district court will only have their record at that level. These convictions do not fall to the county court once they've reached the federal level. So federal crimes can include crimes over state lines, prescription fraud, federal motor vehicle theft. You'll see drug trafficking, gun and weapon charges. You'll see internet crimes, from terrible things like child pornography to money laundering. So for hospitals, if you're not including federal records, you could be missing federal insurance fraud again, or prescription fraud, and then all these drug related charges as well. So across the US, there are 94 federal courthouses. Cases can get moved easily, so you should be running them all. You see some of these high profile cases. Let's say that it occurred in district court in Iowa. It's someone local to the area. They wanted to move it to get a more neutral jury. They move it to Wisconsin. Well, now that charge is only going to be found in Wisconsin. So make sure that you are searching it and not just doing it at the level or the place that they had lived. So I often get asked why background check companies omit this search, and I'm telling you, it's simply because it's not easy. It's labor intensive and often expensive. But at OneSource, we understand the importance of it, and we provide this in every package to our healthcare clients. So I encourage those of you here today to look at your process and ensure that you are receiving federal records. If you're not, ask your screening vendor why they are not providing it. All right, so another layer, another place there could be information on an applicant is the sex offender registry. Make sure that you are searching this in real time and it's not a database-driven search. Records are added to state registries and the national registry every day, so you should be searching it again in real time. Our solution includes the registries from all 50 states, all outlying territories and islands, and then there's over 100 tribal registries as well. They do have separate registries which we will search. And then the last component, it's what we call our global report. You'll see other screening companies may call this a Patriot Act search, or OFAC, which stands for the Office of Foreign Asset Control. These searches include healthcare sanctions, OIG and SAM, which I'll get to in a little bit, FBI, DEA, wanted watch lists, Interpol. You will see some countries, European Union watch lists, Department of State Trade Control, financial sanctions. At OneSource, our global report does include 76 different components, and it is across a wide variety of government wanted watch and sanction lists. So essentially, this helps capture applicants that could be on one of these lists and not necessarily have a conviction yet. So after those 6 components, those are the most important things to include on your background check. Those are criminal records and information. There are plenty of other searches that are commonly used by hospitals, and I've listed some here. Abuse registries. Most of us are familiar with the Nebraska Department of Health and Human Services, their adult and child abuse registry. We can assist with that. Your vendor should be assisting with that. License verifications. Do you want to verify a RN license? Employment or education verifications, employment. Are we verifying the position that they held and the dates they were employed? Are they applying to be a CNA? They said they had CNA experience, but we find out that they were actually a custodian at a previous hospital, right? We'll flag that for you. Education verifications. Well, what was their graduation date and what was the degree they obtained? Are they applying to be in the healthcare space, and saying they had a biology degree, but really it was in accounting? We can flag that for you. Social media searches, these are becoming ever more important, especially for public facing positions, executives. Do they have a public profile where they've posted things that are sexually explicit, have racism or intolerance included, drug-related offenses, violence? Are they posting those things? We can provide that information to you in a compliant manner. Motor vehicle records. Are they going to be driving a hospital vehicle? We can help show you that their license is valid, or if it's revoked, suspended, or expired. And then healthcare exclusions as well. Speaking of those, that is our last topic, so I'll dive into that a little bit more. But know that your screening vendor, and especially OneSource, can tailor and provide quite a few solutions to you. At OneSource, we truly want to be the one source for background screening for you. So we can build packages and try to provide you as much, take as much off your plate and provide you as much information as possible. All right, as mentioned, healthcare exclusions. We're going to cover, what are they, why are they necessary, and then look at the types of ways to obtain exclusion information. Before we dive in too deep, what are healthcare exclusions and why are they important? Essentially, these are final administrative actions by the federal government that prohibits an individual or entity to participate in a federal healthcare program. The individual or the entity poses a risk to patient care or program fraud. So it's important that if anyone is found on the list, then Medicare, Medicaid, TRICARE, they won't pay for services provided either directly or indirectly by an excluded person or entity. So these federal healthcare programs, again, Medicare, Medicaid, they subsidize about 60 to 65% of hospital dollars spent in the United States. If there's someone on the list, then they're employed at your hospital, there are fines, suspensions, license suspensions, and other repercussions that can happen. The fines can be executed in upwards of $22,000 per violation. That's per incorrect billing or per patient that they worked with. And then the assessments can be upwards of 3 times the amount that was claimed or billed to Medicare, Medicaid, TRICARE. So there's some serious repercussions there. And if you have someone at your facility working that is on one of these exclusion lists, you need to get them out of there, because the financial repercussions can be very, very grand. When it comes to exclusion screening at the federal level, there are different sources and places the information is held. The 2 federal sources are the OIG, the Office of Inspector General, Health and Human Services, HHS, not DHHS like in Nebraska. They do have a list of the National Health and Human Services does have a list of excluded individuals or entities, which they call the LEIE. The Office of Inspector General was created essentially under congressional mandate to establish a program where excluded individuals and entities affected can be listed. This is all in the Social Security Act, I believe section 1128 and 1156. They maintain that list of excluded parties, and again, they call it the LEIE. The legislation was made to prevent certain individuals or businesses from participating, again, in their federally funded healthcare programs. SAM, that's the System for Award Management. Formerly, it was known as the GSA, or General Services Administration, or the EPLS, which is the Excluded Parties List System. SAM combines the federal procurement from Catalog of Federal Domestic Assistance, and several others into one system. And it was created under the Affordable Care Act to essentially provide a broader data set of individuals and entities that are debarred, sanctioned, or excluded. So in addition to these 2 federal sources, there are also the state Medicare exclusion lists. Each state has a department or an agency that they've created that is dedicated to upholding the integrity of the Medicaid programs in the state for public health. Each state can vary by name, and the function and the restrictions can vary, but essentially these provide another layer for protection for the government, right? So in Nebraska, the list is the Nebraska Medicaid Sanctioned Providers List. And as of last evening, I did go through it, and there were 1,117 people or entities on that list here for Nebraska. So how does somebody, an individual or an entity or business, end up on these lists? It can be convictions related to defrauding the government-funded healthcare programs, which we discussed. It can be unlawful manufacturing, distribution, prescription of controlled substances. It could be suspension, revocation, or surrendering of a license due to competence, performance, or financial integrity, submission of false or fraudulent claims, again, to the federal healthcare programs, unlawful kickback arrangements, defaulting even on healthcare loans, or controlling a sanctioned entity as an owner, an officer, or managing employee. And that's how the entities can get involved as well. So these are just a few of the reasons that somebody could end up on one of these sanctioned lists. Okay, so we reviewed OIG SAM, which are the federal lists, and then we briefly went over the state Medicaid lists as well. In Nebraska, we do have that Medicaid Sanctioned Providers List, which, like I said, roughly 1,100 people on it. It's not always practical as an employer or HR person to go in and look at that list, which actually is a PDF with every new hire. So that is where a compliant background screening company like OneSource can help. We have an excellent solution, which we call Medical Exclusions Level 3. This service searches the federal sources and then every state's exclusion list, not just Nebraska, but every state's list. In its entirety, there's over 2,000 total authorities that do report to this search that we have. It is a full scope as you can receive to capture any exclusion information that may be out there on an individual or an entity. So it is an excellent solution for those that want or need to take it a step further than just those federal requirements for OIG and SAM. It is important to note that anything found here, it does need to be verified at the source. OIG and SAM are usually updated monthly. This search is updated more frequently than that, but we do want to make sure that somebody didn't come off the list or be added yesterday and then show up today. So looks like we actually have a question here as well. Can people come off or fall off these lists? Yes. So kind of just mentioned it briefly. You can. Being on the list doesn't mean that you're on it forever. The sanctions can vary. It's kind of like the sex offender registry, right? You could be on it for life. You could be on it for 10 years, 5 years, 1 year. But that's why it's important to continually run your staff to make sure they haven't shown up on one of these lists. If they're working another job where they could have had a violation you may not be privy to. We usually recommend doing this at least monthly. Some facilities do it yearly. Some just do it on hire, but it is good practice to do it more often to ensure that the lists are clear and your employees are not on them. So that actually kind of takes us to our last part here, which is monitoring. So remember the penalties that I mentioned. It can be repayment of all the funds received from Medicare, Medicaid. Then there's also the fines. It can be suspended, licenses pulled. The fines can be upwards of 22,000 per violation, and again, those assessments can be up to 3 times the amount that was claimed. So, due to many hospitals and healthcare facilities, being wary of this, they do want to screen their staff on a more frequent basis. I just mentioned it, monthly in some cases. So this can be done by spreadsheet uploads or other ways. Most screening providers will have a process where you can upload them securely, a list of everyone that you want to run each month or annually. Sometimes this can be a little tedious, obviously, depending on the size of your hospital. But at OneSource, we do offer an ongoing monitoring solution where these exclusion lists are being monitored daily. So simply enroll your staff into the monitoring system by placing an order in our system. And then after that, you'll be notified of any exclusion list activity that is then verified at the level, whether it's federal or state, for confirmation. So it really is a fantastic solution. I'd love to connect with anybody that has questions about it, but it is a good way to enroll your people and know that we are constantly searching every day to see if they're on any of those 2,000 plus authorities that are exclusion sanction lists that are out there. All right, so I feel like that was a ton of information. Let's just do a quick recap of a few takeaways. First, we talked about compliance. Background screening is a heavily regulated industry. You've got the FCRA, Fair Credit Reporting Act, and then the EEOC guidance, that 64-page document from almost 10 years ago now to consider. So working with an accredited screening provider can help with that compliance, right? Have a good background check policy in place. We talked about targeted screens to take the position at hand compared to the gravity of the offense. Have time limits for how far back you're going to look, and remember to do so from the final disposition, or again, that date they got out of jail, they finished their probation, paid that fine, etc. And then have a rock solid disclosure and authorization form. Remember, this is one of the most litigated parts of the screening process. Include anything that may be searched, ensure that it's in the right format. Walmart was recently sued because they had a disclosure and authorization that ran onto the back page. It wasn't just on one page. They called that deceitful practice. So there are even, those sizing restrictions. So know that it's ultimately your responsibility that disclosure and authorization form is compliant. And remember, here at OneSource, we offer an outstanding applicant order entry option where they can sign that disclosure and authorization form. We'll work with you, make sure it's how you want it, it's compliant, and that will be the one that they sign when they enter the order. And we won't process anything unless that is signed electronically. It takes all the work off your plate. And then we went over adverse action. If you aren't moving forward with a candidate based on the background check, not for other reasons, but if it's based on that background check, you do have to take proper steps to inform them and allow them to dispute any of those findings. So your screening provider should be providing you these letters, but remember, at OneSource, we do offer an entirely streamlined and automatic adverse action process. We also covered quality of data, what you should be including in your background checks, making sure the information is in real time, coming from the original source. I feel like I've mentioned that a dozen times by now. County criminal, make sure that's the first thing that's being searched, and it's always provided statewide when available. So again, all 93 counties in Nebraska should be included. And then federal criminal records, make sure that those are included. So many background screening companies omit that from their packages because of it's expensive and it's a cumbersome search form. Ask them why they're not providing it to you. Ask them what it would cost to add it. Make sure that you're searching all 94 jurisdictions that are out there. And then consider timeframes. Make sure your vendor is providing information back as far as they legally can, and keeping in mind that there are those state-specific requirements as well. Again, using an accredited screening firm, they'll have those steps and have been audited that they have those steps in place. And then lastly, when we went over healthcare exclusions, we reviewed the federal sources, OIG and SAM, which are the minimum requirement to be searched to ensure that you aren't getting those hefty fines and penalties, but also considering that each state has exclusion lists. Then we discussed our medical exclusions, that level 3 search that we do, which includes both federal and all state lists. Remember, over 2,000 authorities are reporting to that. And then how to incorporate that and search for rescreening or using our monitoring service. We can help with that as well. So. All right, so that brings us to the end of the road here. Hopefully everybody found it to be informative. My contact information is here. Please feel free to email me or give me a call if you have any questions. But I'll take, see a question came through in the chat. I'll take any other questions now. Go ahead and type those in there. So, but the question that did come in, we have students that come from universities to do rotations. Can we screen them? That is a fantastic question. There are permissible purposes when you do background screening, employment screening, volunteer screening. There's a student or intern placement screening. Most of the universities and colleges around the region, especially here in Nebraska, do utilize us in some capacity for their student screening. So there's a couple ways you could go at it. One, you could ask the college that you typically, or university that you typically get students from if they are conducting background checks, and let them know to what degree you want them completed, right? Maybe provide them your policy, let them know, hey, we need to make sure these things are searched. Are you doing that? Otherwise, we can set you up a sub account for that permissible purpose of intern placement to where you can run background checks and keep it separate from your employees. But we can certainly help you with that. It is fully within your rights with consent from the student to do that background checks. How long do background checks typically take? That all depends on where the individual is from. In Nebraska, we typically see the results come back in 48 hours or less. There are some states, like for those out in the Panhandle, Wyoming can take a little bit longer in some cases. There are some courthouses we physically have to have a researcher go to pull information. With everything that's gone on in the last couple of years, pandemic-wise, there are some courthouses that restrict how long you can have individuals in the courthouse to pull information. So there can be some delays with that. Usually you see the results come back within 72 hours or less with us, 96% of the time, and over 90% of the time, 48 hours or less. Do we provide discounts to NHA member hospitals? Yes, we certainly do. We do provide a package that is aligned with our NHA Services Preferred Business Partner, and we'd love to take a look at your volume and your facility and see how we can help incorporate our screening services. All right, I don't see any other questions. I'll give it just a moment here. Someone asked, can I send a sample policy and disclosure and authorization? Yes, absolutely. If you want to email me or give me a call, again, information right there on this slide, I will send that information over to you. All right, well, we're getting kind of close to the end of time here, so I do want to thank everyone for attending today. As the NHA Services preferred business partner for background screening, we do look forward to working and speaking with many of you and keeping your business here in Nebraska. Again, you'll find my contact information here. Happy to send the slides out to anybody that would like a copy of them as well, but also available to take a look at your current process, see if we can help improve it at all, or even just take a look at it for compliance as well. So I want to thank John, Mike, and the NHA Services team for allowing us the opportunity to visit with you today. And thanks for sharing part of your morning with me. Again, reach out if you have any questions. Thank you.